adopting resolution.
Okay.
And you would see how the planning commission draft was changed to reflect your deliberation.
Using
We can take those
in the
as a
course.
group, you know, with the map changes, yeah.
Yeah.
There's several areas that there's been a lot of public comment on. And I think for today, I'd like to talk a little bit, or have you talk a little bit more about some real general topics that are common themes throughout a lot of our comment letters. A couple that really come to mind are non-conforming lots and conditional use permits for shoreline substantial development permits. And just in general, what do we look for, what would you have us look for in, as we review those concepts, as they are impacted by Shoreline Master Program and the arguments we have going on in the letters? We have a lot of places where people say, don't do a shoreline development permit, do a conditional use, or have a threshold for something. It's big, have to go here. If you could talk in general about this concept.
And so if we could identify the areas in the code that are non-conforming, there's two sections. One is in section, I know section 10 has a section on nonconformity, and then also page 6-6 has nonconforming lots.
So non-conforming lots are in Article 6 in regards to the buffers and setback, and Article 10 is regarding non-conforming development.
And that'd be pages 6-6 and pages 10-6 of the Planning Commission draft.
And as we go through here, we'll have issues, just for an example, the map thing, whether to include master plan resorts and assessor's plats of record, how to treat those. And, you know, we'll have decisions to make about that concept in some ways that we could create non-conforming lots, or in other ways we do it, they won't be non-conforming. So what would you have us look for in terms of the workload on staff, all those issues that you kind of outlined there that DCD looks at in terms of how to handle permits, how timeliness,
Right.
appropriateness, you know, how it affects the environment, how it affects property rights, all those issues. What would you have us look at? To be clear.
Well, first I would say that section with master plan resorts and plats,
Right.
we're going to draft some different language for you. We have a different recommendation as well to you. So to be more inclusive to plats countywide, could be Cape George, could be California.
And let me clarify that. This is something we currently do. Parcels are vested under a plat, and even if the code doesn't say it, they are vested if it shows a shoreline setback. What we've seen in the public process is that there's a desire to have that spelled out in the code to reflect the actual conditions of when you apply for a permit. So if you would like us, we're prepared to refine that language if you would like us to come back with that.
Some refined options would be good.
And that would mean that universally across the county, plats would be honored. It has legal basis, particularly Noble Manor versus Pierce County, and it depicted site plans with setbacks and numbers and uses. The Supreme Court's ruled in favor of those previous decisions, and so we want to bring that same concept forward. Court level is a great example. Those plats on the water, very small lots. It's not our intention to run them through some bureaucratic machine to get to a point of approval when we know they're going to get approved out of the gate. We're going to try to work with the plat, with the conditions of approval of the plat, the zoning code in Port Level is Title 17, and try to get a good fit for the applicant and for the public. Yes, we'll look through the code, there's processes. You might want to identify the number of ways, if you have a non-conforming lot, if you can meet the prescriptive buffer requirement, you're good to go. If you can't, then you have the following options.
Oh, sure. Yeah, and that's what we've got here on, starting on page 6-6, 6-5 of the planning commission draft is, when a lot doesn't have the depth to accommodate the standard buffer, then this is a series of criteria that, if met, then would allow single-family residential to be built on a non-conforming lot. Now, there's also the common line setback, or staff has recommended calling it the common line buffer, actually adjust the buffer width rather than the setback, but another prescriptive approach, so that if you meet what it's got there, use again, staff has recommended adding some language so that it's a mathematical calculation when needed, rather than just having a line drawn between two nearby objects, just to make sure that no misstep is made and something ends up waterward of ordinary high, because that's not desirable and not legal in terms of overwater residential. But that's another option that's there. And beyond that, for available to everyone, not just those with non-conforming lots, but there is the buffer reduction and buffer averaging options, the critical area stewardship plan option, and then of course shoreline variance option as well.
Yeah, but over and over again, we heard, people saying you didn't want a one-size-fits-all, and many people seeing a one-size-fits-all when they looked at the buffers, without seeing all of those things that really allow this to fit the lot and the situation as well as the whole. So I do appreciate that. Because it's not a one-size-fits-all. The way it's presented here, either the planning commission or your draft.
And I know that's a big issue, when we get to, say, the 28th, we should have a substantial amount of time for you to dive right into that issue. Non-conforming legal lots of record, avoiding constitutional claims for takings, we're not intending to make property unbuildable or et cetera. That's just not our effort here.
Well,
Our effort is to regulate, yes, but
I would add that one of the early drafts didn't have one of the prescriptive approaches to the non-conforming lots. And when we met as staff, we asked Margaret if that was something we could do, because there are a lot of small lots along the waterfront. And having had to take people through reasonable economic use variances where you literally only have the habitat biologist and the applicant, staff, and the hearing examiner there, I was hoping to see something that was more expeditious in our process and didn't waste resources, because if we're going to come to the same conclusion, we could have an easier process. And that was something where Margaret said, yes, they did have something in Whatcom, and they thought we could bring something forward, and that was the 2,500 square feet allowance for non-conforming lots. So it has evolved over it. I think as we go back and forth now, we're happy to answer any questions, and if there's information you need to help understand something or make a decision, we'll do that and get you more language if you choose to direct us.